Okay, we conclude our lectures on freedom of the press with a discussion of the concept of obscenity. So we know that things that are obscene should not be protected, that they should be subject to regulation. And I think generally in the United States, there's a sense that obscene things should be suppressed. That's nice, but the problem really comes in defining what obscenity is. What is obscene? How do we define it? What is it? What standard do we use? Where is it to be found? And who should define it? And also, in what amount of obscene material is enough to suppress a work of some sort? In terms of origins, the strict test in Regina v. Hicklin in 1868 was basically that anything that the state deemed obscene, even regardless of the amount in which it occurs, could be banned, and that the test really was the statute. It wasn't the test for obscenity wasn't based on some average person's views or community standards or something. It was really just what government deemed to be obscene and it defined in the statute. And the court strengthens that position 10 years later in Ex parte v. Jackson. Here is a case that got a lot of public attention in 1934, an attempt to ban a book called Ulysses, which described some sexual encounters in graphic terms. And here the court says that intention is the key. Intention is the key. In other words, was the intent of the publication of the book Ulysses to convey obscene material, or was there some other thing, something else about it, some social criticism or something else, that the obscenity was simply a vehicle to convey? Finally, in a case called Butler versus Michigan in 1957, the court rejects the strict standard in Hicklin, and it substitutes in Roth, decided in the same year, another standard that we actually might find to be quite strict, but this one is less so. So I'll read this to you. The test in each case is whether the book, picture, or publication, considered as a whole, so not broken into component parts, but considered as a whole, not upon any particular class, but upon those to whom it is likely to reach, appeals to the prurient interest. So, in other words, not looking at any particular group of people, but at the average person in the community, and defining that average person using present-day standards. So it's not enough to say, well, some class of individuals might see this, and thus we should ban it. Like children might see it. There's a potential they might stumble across it, so we can ban it. No, that's not the process the court uses. It will consider whether using a fictitious average person in the community who embodies the present-day standards of the community, if that person would find that the work is obscene, that it appeals to some base or prurient interest, then the state can ban it. So the Roth test then, it uses the average person standard. The average person is defined using contemporary community standards. The material would appeal to prurient interests when viewed in light of that average person embodying contemporary community standards, and the material would have to be the dominant theme. In other words, looking at the work as a whole, the obscenity would have to be the dominant theme of the work. So this raises some questions. What is a community, and what is the dominant theme? In a very celebrated case, Jacobellis versus Ohio, the Supreme Court said that the community equals the nation as a whole. In other cases, the Supreme Court has actually defined the community standards regionally, or it is allowed a city or a state to define community standards. And there have been some discussion about whether that's an appropriate way to go about it. How far down do you drill into a community to determine what the standards are? Also, that case, Jacobellis, contained a really famous quotation from Justice Stewart, who said, "I shall not today further attempt to define the kinds of material I understand to be embraced within that shorthand description of hardcore pornography, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that." So he says, I don't know if I can define the kind of material I understand to fall within this category of hardcore pornography. But I know it when I see it. I've internalized some standard. In the past, many centuries ago, pornography was simply defined as any depiction of nudity. Now, pornography involves much more than simply that. Also, in a case called Memoirs versus Massachusetts, the court further clarified the Roth standard to mean that the work taken as a whole, not in its component parts, but viewed as a whole, if it contains even a modicum of redeeming social value, then it is important enough not to be suppressed. So when the court went about enforcing this Roth standard, it got a series of cases. Here we have Bantam Books versus Sullivan, and the court says that commissions cannot determine what may or may not be published. So you can't just have a purity commission or a community standards commission that would go about determining whether some thing can be suppressed or not. In Ginsburg, this was a win for the states, and the court says that portraying material erotically is not protected speech. So an erotic depiction is not a protected speech in terms of its symbolism, and the prurient interest of the erotic material is the key here. Stanley versus Georgia. This was an important case involving police raiding a home and finding pornographic material or obscene material, and charging an individual with violating a statute that criminalizes the ownership or possessing of obscene material. And they raid this person's house and they find the obscene material, charge him with having the obscene material in his possession. And the court says that a state, because of privacy interests, even where a state might ban pornographic or obscene material in other public situations, they may not do so, may not criminalize having obscene material in your home. In a case called California versus LaRue, the court decided that it is perfectly appropriate for a state to take away liquor licenses for establishments that present nude shows, and we've seen that in other instances a state can take away a liquor license serving alcohol in places where violence is likely to occur. Is probably an unwise thing to do, and it's certainly within the state's bounds to attempt to maintain public order. It has much more to do with that than it does with banning or making it difficult for the public to watch nude shows or obtain obscenity. Okay, Miller versus California. This involved, it's similar, I suppose, to Stanley versus Georgia. This is involved an individual who is shipping obscene materials through the mail. And the question there is, if you can have obscene materials in your home, why can't you go about obtaining them, acquiring them in some way and using the mail to do so? California had criminalized the transportation of any obscene or adult materials through the mail. And a closely divided court, 5-4 vote, the court says No, person does not have a right to send adult material through the mail. Court says, we have recognized that states have a legitimate interest in prohibiting dissemination or exhibition of obscene material where the mode of dissemination carries with it significant danger of offending the sensibilities of unwilling recipients or exposure to juveniles. And the court found the transportation of this information through the mail, it carried too much of a potential that it might be seen by people who didn't want to see it. The Miller test used this sort of this Roth kind of construction, using the notion of an average person who's internalized contemporary community standards. If that person would find that the work appeals to his or her prurient interests, then the material is obscene and should not be transmitted through the mail. The state can ban it. Whether the work depicts in a patently offensive way sexual conduct as defined by state law. So here the court defers to the state law in terms of defining patently offensive material or depicting sexual conduct in a patently offensive way. And then the court looks at the work as a whole again and asks whether it lacks serious artistic, political, or scientific value. One can see why Playboy magazine and other magazines attempted quite successfully, actually, to include articles of social importance and on public interest stories, and some extraordinary interviews, including in Playboy magazine an interview with then presidential candidate Jimmy Carter. In the aftermath of Miller, we get a whole series of cases in which it becomes clear that the Roth framework is unworkable. So in a case called Paris Adult Theater versus Slanton, here the state had attempted to shut down the public viewing of pornography, even where admission to the theater was restricted to only adults who sought admission. Okay, no minors, and no one who didn't want to be exposed to the pornography would be. And in a dissent, Justice Brennan basically throws up his hand and says this Roth standard just isn't working. He says, our experience with the Roth approach has certainly taught us that the outright suppression of obscenity cannot be reconciled with the fundamental principles of the First and 14th Amendments. So this is a theater. It is a public theater. The public, adult public, can gain access to it. And there was actually an attempt after the previous case to ensure that no one who didn't want to see the obscene material could see it, and still the court said that the state could shut down this theater. This is a very odd case name, United States versus 12 200-foot reels of film. Obviously, these had been confiscated by the federal government. The court said that government may ban importation of obscene materials even if those materials were for private use. So the federal government, not only can a state criminalize transmission of obscene material within the state through the mail, but the federal government can ban its importation from other countries. And then in Jenkins, the court said that local juries have to follow the Miller standard, but that only hardcore sexual content is what is prohibited under the Miller standard. And finally, also, as Erznozik, very difficult name to pronounce, versus Jacksonville, the court dealt with a prohibition on the showing of any film containing any nude scene at an outdoor drive-in movie theater. The court said that, in striking down the regulation, said that it ranged too broadly. This was a content-based discrimination, and it didn't make a distinction between material nude scenes that might appeal to the prurient interest and nude scenes that the community might accept. It was just an outright ban on it altogether. Okay, so we have just a few other cases here. In Brown, the question is, may a state prohibit the sale of violent video games to minors and require that such video games be appropriately labeled? So this is a question about whether prohibiting the sale of violent video games to minors violated the First Amendment. Is it consistent with the First Amendment? The court says no, it is not. And Justice Scalia writes the opinion here and says, like protected books, plays, and movies that preceded them, video games communicate ideas and even social messages, and that suffices to confer First Amendment protections. So banning these things from their sale to minors, the fact that the individual had not achieved the age of majority yet, does not justify the state suppressing the sale of violent video games. All right, thank you very much for your attention.